Hello, and welcome to today's podcast on key challenges in negotiating for AI in digital transformation. We'll be keeping this fairly brief, but over the next few minutes, we'll be discussing some of the critical issues that enterprises face when integrating AI into their digital transformation strategies. My name is Alex Harbin. I'm a senior associate in Fieldfisher's Tech and Data Group. Today, I'm joined by Chris Eastham, a partner in the Tech and Data Group at Fieldfisher. Chris is also independently ranked as a global market leader in AI by Chambers & Partners. Chris, welcome.
Thank you, Alex. Delighted to be here.
Let's dive right in then, shall we? There's obviously been so much noise in the market about AI over recent months, and organisations are understandably concerned to ensure that they can get the best out of AI whilst mitigating the potential risks. Have you seen any fundamental changes in contracting practices when it comes to AI?
It's a really good question. This is one that a number of clients have been asking, actually. One of the main challenges is that the market for AI is still quite immature. Many enterprises are not yet sufficiently sophisticated in their contracting approach to managing risk effectively when it comes to AI. And so the outcome is that it can go one of two ways. Either they assume that the existing terms will cover it, or that vendors will put balanced terms in place, which then results in material risks to the organisation. Or they go the other way and they put very onerous terms in place that really undermine their ability to innovate, and it really blocks business progress. Now, either way, it's the legal team that tends to feel the heat in terms of the contracts themselves. So it's important to note that fundamentally, AI is just another technology product. Most of the key contracting issues are going to be the same for AI as they are for other sophisticated software products and services. However, there are some specific issues that need to be addressed. Now, if we were to talk about all of the issues that need to be addressed, then this podcast would end up being quite a bit longer. So probably a good use of our listeners' time is to talk about the ones that tend to be highest on the client agenda, and those are those relating to IP and protecting ownership of inputs and outputs.
Okay, sounds like a plan. Should we start with IPR infringement then, seeing as that seems to be one of the first issues that comes up?
Absolutely, let's do that. So when it comes to AI, there are concerns about IP protected material finding its way into the training content. Now, the risks here relate to the potential for third-party claims, alleging that the AI system itself infringes intellectual property rights, or that protected material finds its way into the output. Now, there's a lot of uncertainty here because of the law in this area is very unsettled still. And in fact, we're currently advising on one of the key cases, probably going to be the landmark case in the UK, on this issue. It's made more complicated because the law differs slightly between different jurisdictions. So we might end up with different approaches and potentially forum shopping from potential claimants. The upshot is that enterprises need to ensure they have the right indemnity protection in place to safeguard against these third-party claims. Some of the AI vendors, so if you think about Microsoft and Google, will offer a version of this as standard, although, of course, subject to conditions. The key for customers, though, is to get a sensible level of coverage, addressing not only the product, as you'd expect with more traditional software products, but also the output content.
That makes sense. You mentioned different jurisdictions taking different approaches when it comes to IPR infringement. That's also the case for IP ownership, isn't it?
Yeah, that's right. So ownership of AI outputs is likely to vary significantly depending on jurisdiction. As I mentioned, copyright law in this area is not settled, and interpretations can differ. And in particular, there's a big difference between the way that the US is approaching this as against the UK and Europe when it comes to IP subsistence in output content. And even between the UK and Europe, there's also some variation there. So because of that uncertainty, vendors need to be careful not to over-warrant subsistence of IP rights in output. And when customers are buying access to the AI system, the usual market practice here is that the customer owns whatever IP is in the output to the extent possible. But customers shouldn't assume that that's going to be the case, because it does vary depending on the tool that's being used. And also don't assume that it gives them the protection they need, because there may be no IP in the output content to own. Similarly, a customer might be buying access to a service that where the vendor uses AI to support that service, and in particular, to create deliverables. So in those cases, there may be nothing to stop the vendor, because IP won't subsist, from reusing those outputs with another one of its customers. And so we need to think about what terms do we need to put in place for customers to ensure they're getting good value in the outputs through contractual restrictions, and also taking whatever steps as possible to ensure that copyright does subsist.
Okay, so it sounds like the devil really is in the detail on these issues then. We've spoken about IP infringement and the ownership of outputs, but what about the inputs?
Well, safeguarding sensitive data has been a major concern for the majority of buyers of AI services that I've spoken to about this, ever since November 22, when ChatGPT sort of came to the fore. But besides the practical steps that can be taken, when it comes to contracting, the main focus has been on the scope of the license that the vendor has to use the inputs, and then on the confidentiality provisions. What you'll often see in SaaS vendor standard licensing terms is an ability to use data to improve their services. Now, depending on how that's worded, it could give vendors carte blanche to hoover up the data to feed their hungry AI children. But so customers really need to be hyper vigilant around this to ensure that the restrictions on the use of their data are effective and appropriate to the commercial deal that's on the table, and don't permit broader supplier use unless that's what's intended. So understanding who can see prompts and other inputs and under what circumstances is also crucial. Enterprises really need to educate their users about these risks and put appropriate measures in place.
Okay, thanks Chris for all your insights. That's all we've got time for today, but it's clear that I think negotiating for AI in digital transformation does involve navigating a complex landscape of legal and contractual challenges. We hope this discussion has been useful and provided some valuable information for our listeners to help you stay informed and stay ahead in your digital transformation journeys. Thanks.